In British Columbia and throughout Canada, victims of crime have a right to be heard in court through victim impact statements. But do they matter? Do they influence sentencing? Or are they just a way to placate victims? Why bother? On February 25th, 2026, I gave my victim impact statement in court. Did it matter? In this episode, we'll talk about what I learned. Every year, thousands of Canadians are injured or killed because someone chose to drive impaired. Behind each number is a name, a story, a family forever changed because someone chose to do something we all know to be dangerous, reckless, illegal, and frankly stupid. When you lose someone to impaired driving, you are deeply heartbroken and righteously angry, furious that their death was senseless and preventable. Why? Why do people still do this? Why are Canadian lives still being stolen? Are we really okay with this? Why do we continue to tolerate it? What will make this change? I'm your host, Amanda Bickell, and this is LIVID, Learning, Insights, and Voices on Impaired Driving. This podcast is about real stories, hard truths, and how through learning and honest conversation, we can move from anger to action and work toward a Canada free from impaired driving. It's time to be livid. LIVID discusses impaired driving, traumatic loss and grief, and the justice system. Some content may be emotionally difficult, especially for those personally impacted by these issues, and so listener discretion is advised. The views shared on this podcast are personal and educational in nature and not legal, medical, or professional advice. Where legal cases are discussed, details are shared responsibly and based on publicly available information or personal experience, and nothing shared here is intended to prejudice ongoing proceedings. Our goal is awareness, understanding, and change. Welcome back. In this episode, I'm sharing what I've learned about victim impact statements, their role in court in British Columbia, and what it's like to write one, as well as present one at a sentencing hearing. Victim impact statements have been a formal aspect of the Canadian justice system since their introduction to the Criminal Code in 1988 through Bill C-89. Victims' rights advocates didn't stop there and continued to press for changes that would improve the participation and recognition of victims in the criminal justice system. These efforts, plus experience over time, led to many changes in the process, resulting in the Canadian Victims' Bill of Rights, which came into force on July 23, 2015. This law gives every victim in Canada the right to participate in the criminal justice system, which includes being able to present a victim impact statement. The law states that the court or review board must take a victim impact statement into account when sentencing an accused person or when making other decisions about a person found not criminally responsible. Gratefully, most Canadians will never be faced with the task of writing such a thing. By sharing my experiences of preparing my victim impact statement and reading it in court during the sentencing hearing, I hope to give a glimpse into what it's like. When most victims are asked to do this, the first questions that come to mind are, why bother? Will it really matter? Spoiler, yes. Yes, it really matters, in more ways than you expect. I've got some of the research that explains how and why. That's all in part 1 of this episode. In part 2, I will share my statement, the one I read in court. Here's my story. The provincial courthouse in Vancouver is in a really rough part of the city. It is on the corner of West Hastings and Main, in the heart of the downtown east side. As you approach court, you must face the human suffering of homelessness and addiction. The building is old. There are no windows. It is typical of its 70s-era construction: caramel brown bricks, concrete, natural wood, sound muffling features on the walls and ceilings. It feels cold, close, suffocating, as I imagine a prison to feel. This was the second time I'd been to court, ever. I came once before in April of 2025 to hear Abbey's killer plead guilty, so I knew what to expect. But on this second visit, I felt the heaviness, the burden of the day before us, and the setting seemed to support the gravity of it all. As you enter the building, you are stopped immediately by security. One at a time, each member of my family emptied their pockets into plastic bins and surrendered their purses and bags for both manual inspection and scanning. The guard smiled at me as he saw the framed picture of Abbey in my bag. "Lots of people with pictures today," he said. I replied, "She was really special," and the tears welled in my eyes. We then passed through a metal detector ourselves, stopped on the other side by security guards with wands to check for anything the scanner had missed. Finally cleared, my things collected, and myself put back together, I passed into the hallway of the main floor to find smiling faces greeting me. The tears spilled at that comfort. Abby's friends were there. They had come for her, for me, for them. I hugged them one by one in gratitude and welcome. I looked up and saw my son's friends, my son and his partner. So many people, so much love. And the building no longer felt unwelcome. It was now our space. Our victim services caseworker was also waiting for us and greeted me with tissues and a hug. She's wonderful, and I immediately felt at ease, safe. She guided us to the 5th floor, to the courtroom assigned for the case of the day. As we emerged from the elevator, more friends were waiting to greet us, our fellow victims. Abby's friend Scott, who was the driver of their car that day, his parents, his partner, his grandma, their friends, all those were there too. So many people, so much love in this awful place for this awful purpose. The impaired driver's family and friends were there as well, of course, waiting in the same hallway just outside the same courtroom door. It was awkward. No one made eye contact when I looked, but they were watching. I can't imagine the group of 40 of Abbey's people gathered, greeting, smiling, embracing, happy to see each other, offered the same energy and comfort to the killer and his small group of family and friends as they did to me. And then the door opened. It was time. We entered the courtroom from the back, passing through rows of perforated metal seats fixed to the floor with armrests between each one, an aisle in the middle, and all facing the bench. The cold practicality matches the building. Again, though, once Abbey's community all settled in, we made it ours. We were all seated on the left of the aisle, the side where Crown Counsel was sitting, our side. We sat at the front. We wanted to be able to see and hear. The impaired driver joined his defense lawyer at the table in front of the bench on the right side of the room. He was slouched in his seat, head down. He was dressed casually in jeans, sneakers, and a gray anti-establishment hoodie. Interesting choice. His community of 8 or so filled seats behind them, on their side, at the back of the room, in some of the last rows. I wondered if this was purposeful or instinct, creating distance, not really wanting to see or hear. All rise. We were underway. This was really happening. Without even knowing it, I've been working on preparing for this day since mid-August of 2023. After the initial shock and the crisis of the first weeks after Abby's death, when we had returned home and we were alone with the reality, I started working on grief and working to understand what this meant for me. Through the day-by-day progression of the aftermath, each shock, each step of the investigation, each delay, each first passing us by, I was understanding more fully what it meant, what the impact of this crime was having on me. But when it came time to write, I was overwhelmed. There was just too much. Throughout this entire ordeal, from the first contact with the RCMP, we have had a victim services caseworker assigned to our file. These people have been my anchor and my navigators, and I am incredibly grateful to them. Again, our caseworker helped me to focus, clarify instructions, and manage our expectations. I was reminded, quote, "A victim impact statement is a written statement from a victim that describes the physical or emotional harm, property damage, or economic loss which the victim of an offense has suffered. The court must take the statement into account when an offender is sentenced. The victim impact statement gives victims of crime a voice in the criminal justice system. It allows victims to take part in the sentencing of the offender by explaining to the court and the offender in their own words how the crime has affected them. I was also clearly cautioned not to include anything prejudicial regarding the offender. I was basically advised that it is best to speak only about the direct impact on my own life and the relationships I have with those I love. Again, the official instructions state, quote, "You must not include comments regarding the accused, descriptions of the facts of the offense, do not relate what happened, or your thoughts on the sentence that should be imposed without the court's approval." There's a difficult balance to strike. The impact of losing your child can't really be described in words, but you must. It is very personal, but once submitted, becomes public. Not only does the statement become part of the legal file and public record, but it is shared with all kinds of people in the justice system and with the offender. The British Columbia Review Board has posted information for victims that informs as follows. When a victim impact statement is submitted, it becomes part of the case file and evidence for future hearings. As such, it is provided to all parties, including the accused, a representative of the forensic system, and a representative of the Attorney General, Crown Prosecutor. If the accused is a young person as defined in the Youth Criminal Justice Act, the statement will also be sent to their parent or guardian. So knowing this, you have to be really clear on what you are okay with sharing publicly. And for me, I wrestled with a lot. There is still social stigma around being a victim. I wondered if I really wanted to showcase my wounds in this forum, to open up about the devastation and the grief, not only to total strangers, but to the person responsible for them. I worried about a lot of things. I worried that people would judge me, consider me too dramatic or weak. I worried that the offender would discount my statement entirely, laugh, or even find some sick and twisted joy in truly knowing the pain he caused. At the time, I knew absolutely nothing about him. I had no idea what further harm I might face by allowing myself to be vulnerable enough to do this. I also considered how my loved ones would feel about my hurt. Losing Abbey is not just my loss, and the struggle with the grief is not just me figuring out how to deal with her death. It's also learning to live in a world where everyone I love is hurting too, and none of us can fix it. Watching someone you love struggle, seeing them in pain, is heartbreaking. Knowing that my family and friends would hear my pain, knowing that it would hurt them, and knowing that they would continue to be helpless to solve it, I wondered if all this hurt could be worth it. This led to the question of what's the point? If I do this, what good comes from it? Officially, the purpose is to help the judge understand the impact of the crime on victims so that the gravity of the offense can be considered in sentencing. I had a hard time with this. Like, should it really matter whose life had been lost due to the actions of the impaired driver? Did I really have to articulate my worst nightmare just for the judicial system to get it? Shouldn't it be obvious? I had so little faith in the justice system at the time that I even shared my cynicism with the Crown Prosecutor. I asked him, why would we go to all the trouble if these have no influence on sentencing? He was very patient and acknowledged that there is no certainty in whether the statements will influence sentencing or not, but he said, not submitting them says something too. He also explained how all of the rules in court help to create the fullest understanding of the case. The investigators bring the facts of the case, itemizing and collecting the evidence of what happened, what was criminal. The Crown Prosecutor relates those facts to the law to prove the charges are warranted. The defense ensures that the Crown isn't overstepping the mark and also brings understanding of the offender to the court, who they are, their history, their character, the unique things about them that help the court understand what led to this and what should be considered in sentencing. The victim impact statements bring the understanding of the victim. Without these, the court hears nothing of the victim other than what is relevant from the facts of the investigation. I got it then. I wasn't really doing this for me. I was doing it for Abbey. In all of the files, the investigation, the reports, the pictures, the legal arguments, and in everything about this case, Abbey was just a dead woman. She was the fatality sitting in the passenger seat. In all of this time, through all of the procedure, she was sanitized, easy to overlook. In some ways, I understood this. I imagine that in order to do a good job at investigating, prosecuting, defending, and adjudicating, one must keep a clear head. And allowing yourself to identify with the victim as a person, once living and breathing person, just like you, just like someone you love, would make these jobs intolerable. In this realization, I was reminded of the day after she died, when we met for the first time with the RCMP investigation team on the case. We were in a little room in the Burnaby RCMP Police Department. There were 6 of us: me, my husband, my son, the lead investigator, his supervisor, and our victim services caseworker. They had finished sharing what little information they could. It had only been 24 hours. No one knew much. They had answered the questions they were able to answer. They had given us some of her personal things that they'd retrieved from the crash but didn't need. It was awful, polite, official. For some reason, I wanted to bring Abbey into the room. And without thinking, I took my phone and I showed the officers and the caseworker a picture of her. I wanted them to know who they were working for, to see the vibrant person we loved and had lost. They changed then, all 3 of them. I could see it. Things softened just a little. The people behind the roles and the titles broke through ever so slightly. It was selfish. I understand now that by doing that, I tore down a little bit of what they use to protect themselves as they do this work. I also saw the power of being able to relate. Felt like we had our best chance for a solid sentence by letting the court know Abbey, to understand who she was and her relationship to her friend Scott, who was driving that day. And since she couldn't be there to speak for herself, it fell to her friends and family to tell her story. And there was only one way to do that. So I needed to write a victim impact statement. But how to start? As I was doing this, I found it really helpful to listen to how others managed to complete this task. And so I'll share my process. Maybe it can help someone. I feel like I had a lot of help from a fortunate, intuitive choice that I made on the day Abbey died. That very first night, I started a journal. I've written to her nearly every day since. I still write. When faced with the question, how did Abbey's death impact me? I surprisingly needed to refer to these notes. So much of what had happened in that first couple of years since her death was experienced in sleep deprivation and survival mode, that I had lost sight of all that had gone on, and I was oblivious to how I'd changed. It took several attempts to read the entries to serve my purpose. I quickly got lost in reliving sadness, desperation, and grief. I couldn't very well submit the 350,000 words I'd written thus far. I needed to synthesize these everyday reflections into something more precise. It was hard to review with a mind for identifying the patterns and the changes that would constitute impact. I also looked to others for help. I worked with my victim services caseworker. I reviewed instructions. I looked at videos, guides, and examples on the Mad Canada website too. All of these were really helpful with the structure and the rules, the intent, and so on. But my story, Abbey's voice, that was so much harder. Finally, I just sat and wrote. I wrote a lot. I cried and wrote. I didn't edit anything. I took the strategy of just writing everything as it came to mind, like just letting it all out, one idea flowing into the next with abandon, often getting off track, regularly breaking all the rules. I just wrote. Then I went back and started editing. I took out all of the things I wasn't allowed to say, or I found a way to include them and not break the rules. Then I looked for patterns, decided on a structure, and organized my ideas within it. Then I rewrote, edited, and fussed with it a lot, and cried a lot. I sent it to trusted friends for editing and feedback, and then finally I settled on it and I submitted it. It took several weeks, and each working session was exhausting. The emotional labor of seeing your tragedy in black and white just really cannot be described. So if you are listening to this and you are facing this task, please look after yourself. I found it helpful to take my time. I learned to prepare for the weariness that would settle in after working on it and to give myself time to recover. I tried to have things going on that would help me to balance the sadness with some joy, to avoid wallowing or falling into despair while focusing on this work. I needed support. I found it helpful to have someone to talk to after writing. To say my therapist was a lifeline in this time is no exaggeration. I hope that by hearing my experience, you won't underestimate the toll it takes. Since the objective was to bring Abbey to life for the court and to explain the family-like relationship between her friend Scott, who gratefully survived the crash, and our families, we needed to hear from people from all of the different areas of her very full and loving life. So we asked others to submit a statement too. In total, there were 21 victim impact statements presented to the court. Each brought unique perspectives and shared aspects of Abbey's life and her relationship to Scott, who had watched her die that day. They highlighted different types of loss and suffering and the aftermath, and together they did a far better job of explaining and sharing who she was and why she was so loved than any one of us could have. Scott, the surviving victim and friend, was also supported with these. Of course, he submitted a statement on his own, but friends and family of Abbey are largely friends and family of his as well. And when both of them are loved by you, you can't help but grieve for the young man he was before the crash. Knowing how difficult it is to compose and share such a thing, I am unspeakably grateful for everyone who did this. In total, 21 impact statements were submitted to the court for this case. This is highly unusual. According to Government of Canada research, only 11% of cases have victim impact statements submitted at all. Why so few submit is not clear from what I've found. However, there's research to suggest some of the barriers that could contribute to low participation. It would be more difficult if the offender who made you a victim was someone known to you. Some victims fear retribution or retaliation. Literacy can also be a barrier. Comfort with and trust in the court and justice system are required, and those are not universal. You need time to do this well, and if you are struggling for any reason, physically, financially, mentally, this task may be too much. Court must consider victim impact statements, and most judges report the information included in victim impact statements is useful to them in considering a sentence. The vast majority of our day of court was dedicated to them. Introductory statements from Crown Counsel included a summary of the events that had led to Abbey's death. Video footage of the crash was played in court, and images of the wreckage were shown. Then we were invited to read our statements. 7 people read their statements in court themselves. 2 were read by Crown Counsel at the request of the victims who'd authored them. The remaining were submitted to the court and become part of the record to be considered by the judge. This degree of participation is again extraordinary. In Canada, on average, only 10% of those who have submitted a statement read it in court. Understand why? Despite my experience with public speaking, having taught in post-secondary for over 20 years, I found this really difficult. We were invited to the witness box to read. Sitting there, I faced the judge and the offender. I was really nervous, and I was shaking so badly that I had trouble keeping my place to see what I was to say. As I shared my pain, I alternated between looking at the judge, the offender, his supporters, and our family and friends that I could see from where I sat. The most reassuring face was the judge's. The offender never looked up, just continued to slump and look at his feet. Defense counsel looked at his notes, never once giving any indication that he was even paying attention. Looking at my friends and family was too painful to see their tears, the hurt. But the judge was stable, and this was supportive. He listened carefully, thoughtfully, made notes as he listened. He looked around the courtroom to see the reaction of others. He could monitor, so I didn't have to. It helped. As the sentencing hearing approached, we learned that we could also submit pictures with our statements. Many of us chose one, added it to our written submissions, and then we had them framed and brought them with us to court. I had brought my picture of Abbey with me to the witness box. I set it in front of me so that she was looking at both the judge and the offender. I found looking at it helped me to stay focused on why I was there. I still wept. I managed to stay coherent, but the tears streamed down as I focused on each word, making sure every one was heard. According to our victim services caseworker, there was not a dry eye in our company, and people were very uncomfortable on the other side of the court. Some have said that listening to me drone on is worse punishment than anything the court could prescribe. It was said in jest. But there may be a grain of truth there. If there is any remorse in this offender, any hope for real understanding of what he has done, then I had hoped that this message would find it. Perhaps something a victim says could be the seed of change. But I saw no reaction, nothing registered in the expression, which remained stoic, head down, shoulders slumped. I wondered what he was thinking. Was he hearing it at all? Had he tuned out? Maybe he was just hoping I would shut up, or wondering if I ever would. There is some research to suggest that victim impact statements do affect the offender. In cases where statements have been given, there is evidence that the chances of reoffending, the objectively measurable bit, are lower, and so it's reasonable to suggest that they also have other influence. I don't need to know for this case. It's more important to me that I did my part. What he does with it is entirely up to him. The statements of all the other victims followed mine. I'd practiced mine. I knew what was in it. I knew the reaction I had to it. I was prepared for it. But I wasn't prepared for hearing and seeing others give their statements, hearing what Abbey meant to them, how her loss has left them grieving and changed. This was really, really hard. For many of the statements, it was the first time that I had heard their story. And it dawned on me that I have been so consumed with my own grief that I had a sort of tunnel vision. I was blind to much of what I knew others were going through, what they were dealing with, but I couldn't bear to see. I heard how Abby's friendship will be missed across so many lives. I saw my parents declare heartbreaking emptiness at the loss of their only granddaughter. I heard what it means to my son to have lost his only sibling, to now be an only child. I heard about the horrific impacts on Scott and his family. This glimpse into survivor's guilt broke my heart in fresh and dreadful ways. I learned of the fallout to Ronan Rescue, Abby's employer, the company our friends own and rightfully take great pride in, and the struggles to keep fighting on through ridiculous bureaucracy related to the crash, all while caring for the tight-knit group of employees, customers, and the rescue community who had also lost Abbey. I witnessed extraordinary courage and bravery and love in the sacrifices made to support and protect us in all of this. I saw parents trying to help their children navigate this tragedy, young adults who were forced to grow up so fast. It was all before me that day, and it was a lot to take in. After the victim impact statements, the Crown Counsel and Defense Counsel made their submissions for recommendations for sentence. In the next episode, I will tell you about them. But as we left court that day, and I was working to integrate everything that I had seen and heard, I was simply feeling tired and very grateful for the opportunity to have had my say and to hear from others. We will never know to what extent the victim impact statements influence the sentencing decision. There are many, many sentencing principles in place within the legal system that judges must consider, and these statements are just one of those many, many things. Research is mixed on the influence of statements on sentences. Some suggest that they have little impact. There is some thought that they may help to clarify for the court the degree of harm caused by the crime, which is of relevance in sentencing. Others propose that the emotionally charged nature of the statement risks bias. Most agree that cases where victim impact statements are read in court have marginal, if any, effect in causing harsher sentences to be imposed. So, if the impact on sentencing is uncertain and minimal at best, why do it at all? I learned a lot about myself and about my grief in this process. It was hard work, but therapeutic and worth it. But the most important good that came from this process was found in the relationships of the people who participated. Although we all love Abbey, we don't talk about her like we did that day. Every single person who attended to support us in court witnessed this pain and in doing so suffered alongside us. Through their presence, we felt loved and supported, and Abbey was honored. Many of us have sought individual help from grief and trauma counseling experts since this awful thing was done to us. I suppose at some point we could have eventually come together into a group, like some therapy event or some kind, but we didn't. And I don't think we ever would have. Grief is so uncomfortable. Each of us is hyper aware of how sharing our thoughts about her brings joy, but also incredible pain, and we are all hurting so much. We end up choosing to carry our thoughts alone, trying to protect and respect everyone else. It was only through this formal process that we did finally share. We now understand one another far better. The door has opened to these kinds of conversations, and I'm finding them more frequent and less awkward than they were before. So for those who spoke, for those who had their statements read, for those who sent me their statements so I would know how they felt, and for those there in support, we have shared truth about what this has meant for us. It has normalized the everlasting impact it has on us and given us permission to talk about it. That is of great comfort to each and every one of us. Not all victims who submit statements report this degree of satisfaction, but 4 out of 5 say they were glad they participated. Reported benefits include feelings of restorative justice, having a say, being able to speak to the offender, and finding a sense of relief or even closure. Factors that improve the likelihood for victims to feel the experience was positive are very much about the team guiding them. These people give instruction and help to manage expectations. We were really fortunate to have a very responsive victim services team and a personable and approachable Crown prosecutor who helped us to be prepared and comfortable in both submitting to and in participating in court. And I am honored to have been lucky enough to fall under their care. Giving a victim impact statement was an incredibly valuable experience for me. It was cathartic. The court heard about Abbey, the incredible, living, breathing, loving person she was. She was humanized again. We honored her. Our love and support for Scott was declared publicly, defiantly. The formality gave all of us permission to be heard, and through that, we now all understand one another better. So do it. Take the chance. Be vulnerable. Make your victim impact statements. The understanding is truly an unexpected gift. The costs, those things I worried about, being embarrassed, having people judge my feelings, even giving the criminal the satisfaction of knowing he hurt us, They didn't matter in comparison to the way our relationships grew stronger, all in Abbey's honor. Thanks for listening. In part 2 of this episode, I'll share the victim impact statement I submitted to court. This episode was written and produced by Amanda Bickell, music by Emily Gordon, all rights reserved. If you'd like to check out the references for this episode, you can find them in the description. I've also got them posted to the podcast website at www.lividpodcast.ca. There you can explore to find other episodes and learn more about me and Abbey. You can also find the LIVID podcast on Facebook, Instagram, YouTube, and in the streaming services where you have your other podcasts. Be sure to follow and subscribe to hear when the next episode is available, to get developments on Abbey's case, and find out what I've learned next. Thanks for listening.